Okay, so now that you've kind of had a chance to go through the appellate process, if it resulted unsuccessfully for you, your next step would be to look at what the habeas process is for your individual case. All habeas applications, post-conviction at least, are contained in Chapter 11 of the Texas Code of Criminal Procedure. They are as follows. There is 1107-1, which is a habeas application for a defendant who received the death penalty. Those are only for death penalty cases. They are not for anything else, and they have a very strict way that they are handled. Those are very rare, becoming more rare as the death penalty becomes less and less of an issue. The next one is 1107-2, which would be for any kind of post-conviction challenge when the defendant received probation. This one is handled drastically differently from the other ones, and I will get to that one as we go through it, but keep in mind that that one's going to be very rare as well. Now, the other one if this is a much newer writ that's become available, is 1107-3. This writ is specifically designed to challenge any kind of forensic issue, from junk science to changes in the procedure to even changes in the opinion of a forensic expert. It is kind of narrowly focused on just dealing with actual scientific evidentiary issues. But the main one is going to be 1107. These are for final felony convictions that resulted in prison time. And that's going to be the largest portion of all writs that are ever filed. Under 1107, you have a right to challenge the constitutionality of your conviction. That could be under the Texas Constitution, or more likely it's going to be under the United States Constitution. This is where you're going to get to argue that certain things were not done correctly, even though they don't necessarily appear on the record. And this is what's very important and very useful in the writ, is the ability to add additional evidence into the record of that trial. For instance, one of the major claims in all 1107 applications is going to be whether or not the trial attorney provided reasonably effective assistance to the defendant. This may not necessarily be apparent on the trial transcript. Sure, you've got the state offering some evidence and you don't necessarily have an objection from the trial attorney, or maybe you've got an objection that doesn't really line up with the theory that the state was proposing. But what you don't have on that trial transcript is why the attorney did what he did. This can be very important because the standard for effective assistance is that you are entitled to reasonably effective assistance. You're not entitled to perfect assistance. The courts understand that attorneys are still people and they make judgment calls and they make mistakes. What they don't want is the attorney doing something when there was no real strategic planning behind it. If the attorney chooses to zig versus to zag, they're not really going to hold that against him so long as he had an end goal in mind or a reasonable strategy as to why he chose left or right. What they are going to hold against him is not thinking it through at all. And so you really want to have counsel's reasoning whenever you're kind of presenting one of these claims. And the 1107 habeas application gives you the ability to do just that. You're going to file the application, hopefully with a brief involved that kind of outlines the facts and legal arguments and submits it to the court. And then they're going to go and get trial counsel's response from that. And assuming that trial counsel comes back with a response that kind of shows that counsel didn't really think it through or was unaware or maybe didn't investigate something, then you're on a good pathway to getting some relief. The thing that you always got to keep in mind with ineffective assistance is that there's a two-pronged test. First, you have to show deficient performance, and second, you have to show that that deficient performance prejudiced the client. Some cases, you know, kind of go against prejudice. If the evidence is very clear, more mistakes are going to be forgiven. However, you know, if the attorney failed to investigate something or failed to present evidence, you've got a much better claim there because prejudice is not really assured. We don't really know what would have happened if the attorney had called that witness because it didn't happen. So you've got greater leeway there to kind of argue that this really hurt him, especially if you've got something like an alibi witness or possibly a punishment witness that is testifying for the defendant about, you know, maybe this one instance is a bad reflection on their character, but it's not their whole character. These kinds of things can be very important and can result and have resulted in overturnings of convictions or sentences. The other big area that you want to look at on 1107 is going to be things like prosecutorial misconduct. And this is not just necessarily the prosecutor, but everyone on the state side. A lot of things are imputed to the prosecutor whether or not they were necessarily aware of it. If you've got a dirty cop that's hiding or tampering with evidence, that reflects negatively on the state as a whole, even though the prosecutor may have had no idea it happened. It doesn't matter for our purposes because the defendant was still harmed by that. But you're not going to see it on the record because typically people don't, you know, own up to these things until the case is closed and maybe some additional records could be gotten into that were being hidden before. And these have been a really hot topic over the last few years in terms of writs that have been granted and writs that are currently pending. So, you know, this is a really good opportunity to kind of explore that. Now, the main thing that you need to keep in mind with the 1107 or any of the other writs is that there is no real deadline. So long as the sentence is in place and the defendant is restrained of his liberty in some form or fashion, the writ remains viable. That being said, there is an argument that the state can raise if you take too long, and that's called laches. It's not going to kick in until at least 5 years have passed since the conviction became final. Conviction becomes final at the end of the last portion of the appellate or trial process. So if you pled guilty and had no appeal, 5 years after the date of your sentence. If you went all the way up to the PDR, it's going to be 5 years after the result of that PDR. So you want to keep this in mind because it's not necessarily dispositive. What it does is it allows the state to raise an argument that you have waited too long, records have been destroyed, something like that. They have to show that they are actually prejudiced by this, meaning they have to show that nobody remembers anything, some witnesses have died, records have been destroyed, something like that. But it can be, it can allow the state to deal with the case without actually reaching any of the underlying issues if too long of a period of time has elapsed and things have become in such a manner that it's very difficult for them to deal with your case. So you don't want to wait too long. But you technically have as long as you need. So you've got to figure out where you want to go in there.